So I'd like to tell you tonight, Parkinson's, how does it manifest? Are there different kinds? And the answer is yes. There are 5 stages to Parkinson's, and we are going to go through those stages so that you get an understanding of what they might look like. So even if you have a Parkinsonism, the chances are we'll go through these stages unless something else gets in the way of life for you, like cancer or an auto accident or something like that. These are the stages that a person with Parkinson's or Parkinsonism would typically go through. So stage 1 is unilateral involvement. It's generally one side of the body, blank faces. You notice when someone is walking that they neglect to swing one of their arms, and then you also see they're a little lopsided on the opposite side. One shoulder is down, and that would be stage 1. So stage 2 is, if you notice how the picture looks, we start getting into postural changes, and we get into more of the shuffling gait and the slowness of movement, which later on we'll hear the words bradykinesia, and slowness of movement is bradykinesia. And these have decreased excursion of the legs. So the shuffling gait is certainly a good look at how this manifests. So stage 3, as you notice also in the picture, that we have pronounced gait disturbances and we have kind of a generalized disability. The person is beginning to need more and more assistance. And there's typically at this point in these stages becomes a balance issue. And the tremor, if there is one, and notice I said if there is a tremor, that it becomes more severe at this point or this stage in the game. Rigidity, obviously, too, comes along, and rigidity can be more severe at about stage 3. And there's that word bradykinesia. The slowness of movement is more and more by stage 3. And in stage 4, this is where you give up the driver's license and you start becoming a royal and ask people to take you wherever it is that you want to go, because you're at that point where you're significantly disabled and you need help with ambulation, with walking. You need assistance with some of your activities of daily living. However, you're still functioning as well. Your mind should be there. If the mind is not affected, we'll get into that later. But stage 4 still isn't the worst part. And then stage 5 is not actually, even though it is the worst of the 5 stages, you can still live with it. So at PRO, we really like to talk about living with Parkinson's, and we want to make sure that people live all the way through it. So stage 5 is where we have complete invalidism, where a person is pretty much confined to the bed or to the wheelchair. They cannot stand or walk by themselves, so they really need assistance. Now, this is where we come into talking about what does it cost for somebody to go through Parkinson's? A lot of money. And this is where Medi-Cal or Medicaid comes in. And so we thought that the segue from what I am talking about today to what Lisa and Bill are going to talk about would be really a good, substantial amount of information for you. So then, as I said in the beginning, there's Parkinson's and there are Parkinsonisms. And sometimes you will hear the doctor say to you, sometimes the doctor doesn't say you have Parkinson's disease. Sometimes the doctor will say you have atypical Parkinson's, or you have Parkinson's plus, or you have a Parkinson's-like disease. Well, there are all of those, and they all manifest themselves differently. And so we're going to go through some of the more major ones, or the ones that we hear about most often, and then some not so much. But even more than what I've put in today's presentation, there are others. We'll start with the one that is most often misdiagnosed as Parkinson's, and it's because it is so much, very much like Parkinson's. But it's really like having Parkinson's on steroids. Multiple system atrophy refers to slowly progressive disorders that affect the central and the autonomic nervous system. In several of our meetings of recent, we talk about the autonomic nervous system. This one, where L-DOPA, carbidopa, levodopa works efficiently in the beginning, but then it may stop working very quickly. But interestingly enough, the person with MSA, multiple system atrophy, may suffer from severe dizziness and be prone to fainting, and the disease progresses very much more rapidly than Parkinson's does. So someone with MSA needs to start looking at their bucket list and trying to accomplish what they want to get through in their life, because MSA manifests itself to demise in somewhere between 3 and 6 years. So knowing that is why you want to get your bucket list going, and in any which way get your bucket list going. But in this one, you want to get it done faster. Patients will fall very often with MSA and quickly, which doesn't happen in typical Parkinson's, but it's very much like Parkinson's later down the line. So this one, as we said, it's early autonomic nervous system symptoms such as low blood pressure when one is standing, and issues with the bladder are often signs. So the first three signs of MSA might be incontinence, some cognition issues, and low blood pressure or falling. They also have vocal cord issues, which happens in Parkinson's down the line. But in the case of MSA, in addition to having some volume and some low volume issues, we also have where the person cannot think of words. It's called aphasia. And they might even fall asleep while they're having a conversation. Multiple system atrophy affects multiple systems in the body at the same time. And again, you will notice that it has sleep disorders, urinary and bowel issues, blood pressure. And so we want to talk about improving the quality of life for people with MSA sooner than later because of the short amount of time that it has. An early diagnosis allows people to get to those issues, but getting an early diagnosis is not always easy until the doctor specifically notices the time from when you first came to him or her and the time when the symptoms are moving fast forward. Nuclear palsy, a pet of mine, PSP, but I say a pet of mine because that's actually what my mother was diagnosed with. I'm sorry, she wasn't diagnosed with it. She died. And after she died, we discovered she had progressive supranuclear palsy. She was diagnosed with Parkinson's, and she lived with that diagnosis for 8 years. I had never heard the words progressive supranuclear palsy until after she died. And it's still not, it's heard of more often today than ever before. So knowing that, but look at the symptoms of it. It's a rare progressive disease that it affects gait and balance. People have a tendency to fall often with PSP in the early part of their diagnosis, but they also a lot fall backward. Those are really hard falls to manage. One of the characteristics of the disease is the inability to move the eyes properly. So if you heard Dr. Ikeda in his speech just the other day, we had a difficulty with eyes looking up or eyes looking down. Person with PSP moves their head up or their head down in order to see in those directions. They also have the saccading of the eyes is very much slower, and they also may have to turn their head from side to side in order to see there. Whereas someone with normal vision will more than likely be able to see with their eyes moving, and they can see where they are in space. PSP often shows alterations of mood and behavior, including depression and apathy. And there's mild dementia that comes with it. It's often misdiagnosed because some of the symptoms are very much like those of Parkinson's, Alzheimer's, and other brain disorders. So PSP symptoms usually do not respond to medication. It doesn't respond to the carbidopa levodopa, or it will respond on a nominal or minimal or short-lasting basis. So it presents itself with very slowed movements, rigidity, and stiffness. It typically does not have a tremor. People with PSP also have cramped writing, the micrographia, and it expresses with soft, slow, and slurred speech. And a person with PSP typically has difficulty in swallowing. Well, we notice that in Parkinson's as well as it advances, and it's one of the things that we try to teach about early on so that people understand that swallowing can be an issue, and if and when it becomes one, it can be a dangerous issue. So they can become more forgetful and crankier. And I can, I get forgetful and crankier, and I don't have PSP. But in this particular instance, it's really relating to how PSP manifests, and then having unusual emotional outbursts like crying or laughing at unexpected times. Here's one that really everybody should be thinking about, because normal pressure hydrocephalus is mistaken as Parkinson's and is rarely found out about until way too far down the line. And it could easier been found if people would have had scans at the beginning of being diagnosed. So if you get a fluorodopa PET scan, or the newer version of that is the DAT, D as in David, A as in Apple, T as in Tom scan, that will tell you what's going on with your brain, where the dopamine is located. And even better than that, it'll tell you if you have fluid on the brain. Well, fluid on the brain is what we're talking about with NPH, because fluid builds up in the brain, and it's an abnormal increase of that fluid, which messes with the ventricles and the cavities, and it enlarges them, and it puts pressure on the brain. Symptoms include problems with walking, impaired bladder control leading to increased urinary frequency and incontinence, and progressive mental impairment and dementia. The person may also have a general slowing of movements, or may complain that his or her feet are stuck. They do not respond to Parkinson's medications. Brain scans, intracranial pressure monitoring, and other tests can help diagnose NPH. It's often treated by surgically implanting a shunt in the brain that drains the excess fluid into the abdomen where it is absorbed. So how is normal pressure hydrocephalus diagnosed? Well, as I said, CT scan or the MRI might be that, or the fluorodopa PET scan, or the DAT scan. Cerebrospinal fluid tests would be another way, including an external lumbar drainage test, gait analysis, which is a timed walk test, and then neuropsychological testing. Next. So dementia with Lewy bodies, we hear about this a lot in many of our support group meetings. We talk about dementia, but there's dementia with Lewy bodies, which Lewy bodies are found in Parkinson's, but in Lewy body disease or dementia with Lewy bodies, the Lewy bodies are found there. It's a greater widespread area that they are found, rather than here and there as they might be in Parkinson's. Symptoms may range from primary Parkinsonian symptoms such as bradykinesia, rigidity, and a shuffling walk, to symptoms similar to those of Alzheimer's, memory loss, poor judgment, and confusion. These symptoms may fluctuate or wax and wane dramatically. Now, interesting, as we're going along here, you might notice that many of these sound like Parkinson's, and many of them are, as we said, Parkinson's plus or Parkinsonisms. But this is what makes it very difficult for doctors to diagnose as well. So seeing a doctor more often might get to the bottom of these diagnoses sooner, because you would want to know what you have sooner than later. So continuing with dementia with Lewy bodies, it has visual hallucinations. They are often found as one of the first symptoms, and individuals may suffer from psychiatric disturbances such as delusions and depression. The cognitive problems also occur early in the course of the disease. Levodopa and other Parkinson medications can help with the motor symptoms of dementia with Lewy bodies, but they will not help with hallucinations and delusions. They may even make those worse, and affected individuals may require treatment with antipsychotic medication. So now here's a new one: corticobasal ganglia or corticobasal degeneration. The results from the atrophy of multiple areas of the brain. including the cerebral cortex. And you see some of the pictures there on the right, noticing that the brain is very complex. Initial symptoms may first appear on only one side of the body, but eventually affect both sides, same as if Parkinson's though. Symptoms are similar to some of the features found in Parkinson's, including rigidity, impaired balance, and problems with coordination. But often there is dystonia affecting one side of the body. Now, dystonia is it's like a cramp. It is where the body can't or won't move. It is cramped. Other symptoms may include cognitive and visual spatial impairments, apraxia, the loss of ability to make familiar, purposeful movements, hesitant and halting speech, muscular jerks in the jaw and other parts of the body, and dysphagia, the difficulty with swallowing. But unlike Parkinson's, corticobasal degeneration usually does not respond to medication. And like PSP, it is characterized by deposits of the tau protein in the brain. So then pseudobulbar palsy, I'll never forget the first person that I met with pseudobulbar palsy. I had no idea that there was a name for this. I met this person in Oceanside at a speech that I was giving. And when I asked him how he was, he said, I'm fine, I'm really fine. And I had no idea that someone would cry when I asked them how they were. I didn't know I was that frightening, but it wasn't that at all. Progressive supranuclear or progressive, I'm so sorry, pseudobulbar palsy is a progressive atrophy as well of the brain stem. And the bulb-shaped let me see, I got to get region containing the lower motor neurons needed for swallowing, speaking, and chewing and other functions is impaired. So the symptoms include, that's a tough word for me, but it has to do with muscle weakness for swallowing. And then there's the weak jaw and facial muscles, progressive loss of speech and tongue muscle atrophy, limb weakness with both lower and upper motor neuron signs is always almost evident, but less prominent. Individuals are increased risk of choking and aspiration pneumonia. So making sure that coughing and swallowing is monitored becomes very, very important. But as I said earlier on, people affected with pseudobulbar palsy have outbursts of laughing or crying called emotional liability. So stroke and myasthenia gravis may have certain symptoms that are similar to those of progressive bulbar palsy and must be ruled out prior to diagnosing. In about 25% of individuals with ALS, early symptoms begin with bulbar involvement. Some 75% of individuals with classic ALS eventually show some bulbar involvement. Many clinicians believe that progressive bulbar palsy by itself, without evidence of abnormalities in the arms or legs, is extremely rare. Affected individuals have progressive loss of ability to speak, chew, and swallow. Progressive weakness in facial muscles leads to an expressionless face. Well, we have that in Parkinson's too, but in pseudobulbar palsy, it's really advanced. This one is very interesting to me because most physicians have never seen it. And in my 31 years of doing what I do, I have actually directed people on 2 different occasions to ask their physician if by any chance they could have Wilson's disease, which is a buildup of copper in the system. So Wilson's disease it's rare inherited disorder of copper metabolism in which excessive amounts of copper accumulate in the body. The most characteristic sign of Wilson's disease is a rusty ring around the cornea of the eye, which can be seen by an ophthalmologist, but it can also be seen by normal eyesight. And the primary consequence of most individuals with Wilson's disease is liver disease. And so it's just a matter of getting it diagnosed and getting the copper eradicated from the body. It typically comes on later in life and is commonly includes slurred speech and difficulty swallowing. Other symptoms may include tremor, of the head, arms, or legs. It also has impaired muscle tone and sustained muscle contractions that produce abnormal postures, twisting, and repetitious movements, and dystonia. Slowness of movements, which is bradykinesia. Individuals may also experience clumsiness and loss of fine motor skills. 1/3 of individuals with Wilson's disease will also experience psychiatric symptoms such as an abrupt personality change, bizarre and inappropriate behavior, depression, etc. Wilson's disease is diagnosed with tests that measure the amount of copper in the blood, urine, and liver. So here's a quick list of some of the other isms, and I'm not going to go through each one of them. We have Guam Key Peninsula Parkinsonism dementia. We have neurodegeneration with brain iron accumulation. We have Lyme's disease, which often is misdiagnosed as Parkinson's. And if someone could get to their Lyme's disease long before it manifests to the Parkinson's-like symptoms, it could be treated and could be handled much differently and certainly more appropriately than treating Lyme's disease with Parkinson's. But over and over in the 31 years I've been here, I hear so many people who have found out late on that they had Lyme's disease and not Parkinson's. So when we talk about leave no stone unturned, it's because there are these opportunities to find that maybe you have Parkinson's, maybe you don't, maybe there's something else that is affecting you. And then you want to know, how fast does it go? How slow does it go? How much time do you have to plan out your life? Oh, and here's an interesting one that it wasn't that long ago that I learned about Meji's syndrome, which is a type of dystonia. That's a state of abnormal muscle tone resulting in spasms and abnormal posture, typically due to neurological disease or a side effect of drug therapy. It is also known as Bruegel syndrome and oral facial dystonia. It is actually a combination of two forms of dystonia, blasphrospasm and oromandibular dystonia. So we'll go through quickly. Oromandibular symptoms is difficulty with opening the mouth, or clenching and grinding of the teeth, or spasms in the jaw where it hurts so to open or close or do anything with it. Sideways deviation or protrusion of the jaw, where the jaw is hanging out there one way or the other, and people are trying to talk. Lip tightening and pursing, drawing back of the corners of the mouth, deviation or protrusion of the tongue. I don't know if any of you have seen the person that was diagnosed with Parkinson's, and they sit there with their tongue hanging out and without being aware of it. They have jaw pain, difficulties eating and drinking, difficulty speaking, which is dysarthria. With blasphrospasm symptoms, the first symptom to appear is an increased rate of blinking. We even think of wiggly eyes, which we just did an article on in the newsletter. But this is an increased rate of blinking, uncontrollable squinting and closing of the eyes, light sensitivity, squinting eyes closing during speech, uncontrollable eyes closing shut, and in rare instances, completely causing blindness. In addition, in some patients, the dystonic spasms may sometimes be provoked by certain activities such as talking, chewing, or orbiting. And then other isms would be arteriosclerotic Parkinsonism, post-traumatic Parkinsonism, essential tremor might be considered a Parkinsonism. It's a disease by itself. Post-encephalitic Parkinsonism. And here's one you may never have thought about: drug-induced or alcoholism-induced Parkinsonism, toxin-induced Parkinsonism, and Parkinsonism dementia complex of Guam. So you can find all of these and more on the website, on the Parkinson's Resource Organization website, along with a plethora of other robust articles and information that you may need as you're walking through or running through your journey of Parkinson's or Parkinson's-like diagnoses. And recognize and remember that we are here to help, to educate, and to emotionally support you. And that's what we're doing today, is educational support. So that's all that I have. I'm not going to the next person that we're going to introduce by way of video, and then she's going to come on after with Q&A, questions and answers, is Lisa Ramsey, who's I've loved her from the time we got started. I don't know how many years ago. She has a company called Medi-Cal Consulting. She has been to all of our support groups when they were physical, and she talks about Medi-Cal and demystifying it, but more than that, debunking the myths. So people think that they have to be totally broke in order to get on Medi-Cal or Medicaid. That is not so. So listen in and listen to what Lisa has to say.
Hi, my name is Lisa Ramsey, and I am the founder and CEO of Medi-Cal Consulting Services. I started Medi-Cal Consulting Services from my kitchen table over 18 years ago. The experience I acquired as a consultant from two significant nursing home corporations and as a Medi-Cal worker in 2 counties makes me one of the leading experts in this field. I am passionate about the knowledge I've been blessed with, and I love providing in-depth Medi-Cal eligibility training and consulting services to health facilities throughout California. Holding seminars for seniors and caregivers to assist in understanding the long-term care options is one of the things that I love about being an advocate. What separates my company from others is our group of former Medi-Cal workers who have the information to survey the circumstance and answer questions. This is done at no expense to the consumer. By the end of this presentation, you should be able to identify traditional versus Magi Medi-Cal, understand how income affects share costs, describe exempt, non-exempt, and unavailable assets, as well as understand the Hcbs Waiver as it relates to couples in the community when one of the spouses requires nursing home level of care. Medicaid was signed into law in 1965 by President Lyndon B. Johnson and authorized Title 19 of the Social Security Act, which also produced Medicare. Medicaid does not provide health care directly to individuals. Instead, it covers the cost of their health care services. Individual states decide on who qualifies for coverage, the type of coverage, and the process of paying healthcare workers and hospitals. That is because each state is responsible to oversee and administer its own Medicaid program. The federal government matches state spending, and the matching rate varies by state from about a statutory minimum of 50% to a limit of 83%. States are not required to participate in Medicaid, although all states do. The program is the largest source of funding for health-related services for uninsured or underinsured individuals in the United States. Total Medicaid spending came to $613.5 billion in 2019, accounting for 16% of the nation's healthcare bill. The federal government paid 64.5% of the bill, while individual states paid 35.5%. Since each state is responsible for managing their version of the federal Medicaid program, they all have their own set of rules and regulations. California's Medicaid healthcare program is called Medi-Cal. Medi-Cal provides health coverage for the uninsured or underinsured throughout California, including special programs for the aged, blind, disabled, young adults and children, pregnant women, persons in a skilled nursing or intermediate care home, and persons in the breast and cervical cancer treatment program. People receiving federally funded cash assistance programs, such as CalWORKS, SSP-SSI, or in-home supportive services, are also eligible. Around 13.3 million people have enrolled in Medi-Cal as of January 2018. Over the years, the Medi-Cal programs have changed and evolved. However, the noise of bad information continues. Medi-Cal can be the help we need to take care of our loved ones, but this help is often overlooked. Why is it overlooked? Why is it not utilized? For many, Medi-Cal is ignored because there's plenty of bad information. The misinformation keeps circling around and around. We have heard the inaccurate information so often and from so many sources that many potential applicants think the inaccuracies must be true. Let's quiet the noise and take a look at one of the exciting ways Medi-Cal has evolved. In 2010, President Barack Obama signed the Affordable Care Act into law and expanded the Medi-Cal program to include a new program called Modified Adjusted Gross Income, also known as Magi Medi-Cal. The goal of the Affordable Care Act is to give more Americans access to affordable quality health insurance. This new program was created to allow coverage for those who were uninsured or underinsured. Normally, these were applicants between the ages of 21 and 64 who were not eligible for traditional Medi-Cal. Applicants qualify for Magi Medi-Cal solely based on their income. Assets are not an eligibility factor. For those whose income is too high, they can enroll in health care plans through Covered California. Covered California is a health insurance marketplace. You can go to coveredca.com to enroll and purchase health insurance. Whether you qualify for Medi-Cal through the traditional Medi-Cal program or the Magi Medi-Cal, it's all the same Medi-Cal program with the identical benefits. Only the qualification process is different. If you are over 64 years of age or on Medicare, you will be assessed under traditional Medi-Cal. Traditional Medi-Cal determines if you qualify according to your assets. Now, I would like to take this opportunity to put any misinformation to rest. There are no income limits to qualify for traditional Medi-Cal. Allow me to say that one more time. There are no income limits to qualify for traditional Medi-Cal. Contradictory to the misinformation in the industry, if you are currently receiving Medicare, there are no income limits to qualify for Medi-Cal. Although, depending on your income, you may have what is known as a share of cost. Share cost is calculated according to your income and the Medi-Cal program in which you qualify. Share cost is like a monthly deductible, except it is the monthly amount the Medi-Cal has decided the beneficiary is committed to pay towards their medical expenses. Share cost is based dependent on their income and the program they qualify for.
We lose the sound again, I wonder, Tyler?
When the share cost is met in a month, the rest of any medical expenses will be billed to Medi-Cal. Another difference between share cost and monthly deductible is if the applicant does not have any medical expenses in a given month. They do not have to pay the share cost in that month. The share cost is paid directly to the providers who have provided the service, not to Medi-Cal. The traditional Medi-Cal program has a monthly maintenance need for a married couple in the community of $934. As a means-tested program, traditional Medi-Cal imposes asset limits in order to qualify on certain prospective applicants. Some assets are counted and some are not. Medi-Cal classifies assets in 3 categories: exempt, non-exempt, and unavailable. Some examples of non-exempt assets include cash, checking, savings, stocks, bonds, investments, credit union, and real estate, which is not being properly utilized according to Medi-Cal regulations. Some examples of exempt assets include the principal residence, one vehicle, some life insurance policies, personal belongings, household furnishings, pre-need arrangements, and tax-deferred retirement accounts. California does not have a maximum home equity value limit like the majority of other states. So at this time, there's no limit to what your principal residence can be worth. Unavailable assets occur when the owner of the asset is considered incapacitated and there is no legal authority in place, such as a power of attorney or conservatorship, and no other entity has access to the asset. Also, an asset can be considered unavailable if someone is making a good faith effort to sell or liquidate the asset. The traditional Medi-Cal program has different asset limits, depending on which program you qualify for. An elderly married couple in the community is allowed $3,000 of countable resources. So for example, a married couple with $4,000 in a bank account would be over the asset limit and be required to spend down their bank account to below $3,000 to be eligible for assistance while living in the community. The government realized that many people would not be eligible, or they would have a high share cost, making the services not feasible, or they would be over the stringent asset limit. So the Hcbs Waiver was signed into law. The spousal impoverishment provisions were meant to assist couples with care cost, but were only available when used for skilled nursing facility care. In 2017, Medi-Cal made those impoverishment provisions available to couples who wanted to remain at home through the Hcbs waiver. The spousal impoverishment provisions, when applied, can make in-home care much more accessible. These spousal rules are specifically for those couples where one spouse has become ill and needs assistance. It's possible to have the Medi-Cal benefits applied to the ill spouse and the resources and income remain available to the well spouse. The Hcbs waiver means the couple does not have to use up all of their resources and income to pay for the care of the ill spouse and leave the well spouse impoverished. The Home and Community-Based Services Waiver is a Medi-Cal program that in general provides assistance with skill development, respite, transportation, and other services to help support the individual and their caregiver. Section 1915C, Home and Community-Based Services Waiver, provide opportunities for Medi-Cal beneficiaries to receive services in their own home or community. Medi-Cal has really evolved with the Hcbs waiver. These programs serve a variety of targeted population groups, such as people with mental illnesses, intellectual disabilities, and/or physical disabilities. Hcbs first became available in 1983 when Ronald Reagan signed into law and Congress passed provisions added Section 1915C to the Social Security Act, giving states the option to receive a waiver of Medicaid rules governing institutionalized care. The Supreme Court case, Olmstead v. LC, 1999, found unnecessary institutionalization to be a violation of the civil rights established by the Americans with Disabilities Act of 1990. That service be provided in the least restrictive environment. Olmstead allowed that states would be in compliance with the Americans with Disabilities Act if they could demonstrate that they had a comprehensive working plan to move people with disabilities into less restrictive settings. This provision, along with Centers for Medicare and Medicaid Services, guidance on Olmstead compliance, led to rapid adoption by the states of the Hcbs waiver. Within broad federal guidelines, states can develop home and community-based services waivers to meet the needs of people who prefer to get long-term care services and supports in their home or community, rather than in an institutional setting. In 2009, nearly 1 million individuals were receiving services under Medicaid Hcbs waivers. More than 800,000 people nationwide have been waiting sometimes several years. This creates gaps in services due to variation state to state, population-based inadequacies, state-based inadequacies, and race-based inadequacies. Population-based inadequacies are when half the states spend 2 times as much money on institutional care as they do on this program. Only 8 states spend more than 50% of their federal money on Hcbs. Iowa spends 10% of its money, while Washington, Minnesota, and Oregon spend 70%. Race-based inadequacies occur for many reasons. One in particular is due to the increase in admissions in communities of color and decrease in white populations. In communities with lower earning populations, access to Hcbs is also limited. Prior to the implementation of this waiver, there was community-based Medi-Cal under the traditional Medi-Cal program. When a married couple needed assistance in caring for an ailing spouse, Medi-Cal only allowed a community-based maintenance need for a couple of $934 and an asset limit of $3,000 of countable assets. These stringent regulations prevented most married couples from receiving any assistance when in-home care was needed. This caused many unnecessary long-term care residents to remain in the nursing home facilities or become institutionalized. For example, if a married couple has a total of $3,000 in combined countable income, under these regulations, they would have a share cost of $2,066 a month. This would make Medi-Cal not feasible for this couple in the community. So this couple, with a combined total of $3,000 in countable income, would have a share cost of $2,066 while in the community, and if their countable assets were below $3,000. However, they would not be eligible if their assets were over the stringent asset limit of $3,000 of countable resources. Although, if the one spouse was in long-term care, then their asset limit would greatly increase to $130,380 of countable resources. That's currently for 2021. Keep in mind that this is a minimum and not a maximum. This generous asset limit can even be increased through court proceedings. In the past, most married couples, registered domestic partners, and same-sex couples were unable to utilize the benefits through community-based Medi-Cal when one of the spouses became ill and required nursing home level of care. Either their assets were well over the limit of $3,000 of the countable asset limit, or their share of cost was too high to be of any benefit. The spousal impoverishment provisions also apply to registered domestic partners. All County Welfare Directors Letter 12-36 establishes that the full array of spousal protections that are available to married, opposite-sex couples extend to the same-sex spouses and registered domestic partners. Specifically, the rules regarding the amount of income and property a community spouse may retain when their spouse becomes institutionalized. Medi-Cal becomes necessary when one of the spouses, registered domestic partners, or same-sex couples becomes ill and requires nursing home level of care, also known as custodial care. Medi-Cal has a program called long-term care. When a Medi-Cal applicant enters a skilled nursing facility, long-term care rules apply to determine the month of long-term care status, who is in the Medi-Cal family budget unit, and how to treat the income, property, and proper budgeting.
We're out of voice again, Tyler.
For recognized couples with one spouse in long-term care, there are two sets of rules: the Medicare Catastrophic Coverage Act and the Community Property Income Rules. Which rules apply depends on the date the individual entered the long-term care facility and applied for Medi-Cal. These regulations define new terms such as community spouse, institutionalized spouse, continuous period of institutionalization, and allow the institutionalized spouse to allocate income and property to the community spouse at home without considering the state's community property and income laws. Assembly Bill 641 allows counties to implement the Medicare Catastrophic Coverage Act rules to same-sex spouses and registered domestic partners, effective January 1st, 2012. Medi-Cal applicants who entered a long-term care facility prior to September 30th, 1989, fall under the state's Equal Division of Community Property and Income rules. Under these rules, terms such as long-term care status, separate and community property, and spouse at home all apply. Long-term care Medi-Cal has specific guidelines which include the spousal impoverishment rules. The Medi-Cal spousal impoverishment rules are designed to prevent the impoverishment of one spouse when the other spouse applies for long-term care Medi-Cal or home and community-based services. The expense of nursing home care, which can range from $7,000 to $10,000 a month or more, can rapidly deplete the lifetime savings of elderly couples. In 1988, Congress enacted provisions to prevent what has come to be known as spousal impoverishment, leaving the spouse who is still living at home in the community with little or no income or resources. These provisions help ensure that this situation will not occur and that community spouses are able to live out their lives with independence and dignity. Under the Medicaid spousal impoverishment provisions, a certain amount of the couple's combined resources is protected for the spouse living in the community. Depending on how much of their own income the community spouse actually has, a certain amount of income belonging to the spouse in the institution can also be set aside for the community spouse's use. This means that certain individuals can be eligible for Medi-Cal with more generous income and asset limits, enabling them to access services without depleting all of their resources, and this will ensure share cost goes down. Federal law specifies that certain programs be considered before others when Medi-Cal eligibility is determined or redetermined as they are annually. At application, annual renewal, or when a change of circumstances is reported, the applicant's Medi-Cal eligibility must be determined by progressing through the Medi-Cal hierarchy outlined in All County Welfare's Director Letter 17-03. The applicant may not be eligible for some programs after the screening. Eligibility must be determined for each program where the applicant has potential Medi-Cal eligibility. When an applicant is eligible for more than one Medi-Cal program and one is more beneficial, then the individual should be placed in the Medi-Cal program that is most beneficial for them, unless the individual requests otherwise. Additionally, other home community-based services individuals can transfer property to themselves. Under these spousal impoverishment rules, Medi-Cal allows the spouse, registered domestic partner, same-sex couple who is not receiving Medi-Cal, referring to them as the well spouse. The well spouse is allowed to retain additional assets and income without compromising the eligibility for the ill spouse. Currently, the well spouse individual is allowed to retain a community spouse resource allowance of $130,380 in countable assets. All County Welfare Directors Letter 17-25 requires that the county eligibility worker to apply the spousal impoverishment provisions in the first month when both of the following exist. The request for either home community-based services or in-home supportive services has been made, and the individual meets a nursing facility level of care as determined by a doctor or an assessment by the home community-based services waiver or program. The date that both these criteria are met is known as the applicable application date for spousal impoverishment provisions. To help you understand how this is applied, I'd like to tell you a little story. This is about Romeo and Juliet. They've been married over 60 years, and they've lived in the same home they raised their children in since they married. Romeo is 82 years old. He's retired after 50 years working in the aerospace industry. His beloved spouse, Juliet, is 80 years old, and recently her health has declined. They have $80,000 in a savings account and $25,000 in a CD account. Juliet has been diagnosed with Parkinson's disease and needs Medi-Cal to help pay for her care. Juliet can qualify for Medi-Cal under the spousal impoverishment rules, which will allow Romeo to keep all of their assets since their total amount of assets is below the current community spouse resource allowance of $130,380. Then their income would be verified to calculate whether or not they would be assessed a share of cost. The minimum resource allowance is intended to protect these couples that have limited resources. Remember, this amount can be increased. In addition to the community spouse resource allowance, the well spouse is allowed to retain additional income without having to pay all of their income towards the share cost. The well spouse is allowed to retain all of their income. Their income is only verified at time of application to assess if their income is below the minimum monthly maintenance needs allowance, which is $3,260 for 2021. If their income is below the minimum monthly maintenance needs allowance, then they may receive an allocation from the ill spouse's income to bring their income up to that amount of $3,260. If the well spouse's income exceeds the minimum monthly maintenance needs allowance, they will not be eligible for any allocation of their spouse's income. The well spouse can have unlimited income, and they will not be required to give up any of their income ever. Here is an example of how income is used to calculate a share cost for an elderly couple with one spouse in a long-term care nursing facility. Romeo has a monthly pension of $1,200, and he also receives $900 in Social Security for a total of $2,100. Juliet receives Social Security of $900. Since Romeo is the well spouse, he is allowed to retain at least a minimum amount of monthly income of $3,260. Romeo can keep his monthly income of $2,100 in this circumstance, and he will receive an allocation of Juliet's income of $900 per month to bring his income up to $3,000. which is well below the threshold of $3,260. Therefore, Juliet will have no share of cost while residing in a long-term care nursing facility. These rules allow for the well spouse to retain the community assets and income so they don't become impoverished while their ill spouse is receiving the care they now require. In most cases, once the ill spouse becomes well enough to go home, they were unable to continue the Medi-Cal benefits in the community due to the strict guidelines imposed on community-based applicants. Remember in my previous example, the monthly maintenance needs for an elderly couple in the community under the Age, Blind, and Disabled Traditional Medi-Cal program is $934. So once Juliet was well enough to go home, the Medi-Cal share cost would increase to $2,066, making the benefits not feasible. In November of 2017, Medi-Cal issued All County Welfare Directors Letter 17-25 that implemented a waiver program called Home and Community-Based Services Program. Married couples in the community can utilize the spousal impoverishment rules normally reserved only for long-term care applicants and qualify for Medi-Cal while in the community. In most cases, they would be eligible with a zero share cost. These rulings make life-changing services possible to married couples in the community, such as in-home supportive services and the assisted living waiver program.
When I talk to Bill, we talk about things like the power of attorney for health care, which is so important, and couples don't remember to get this done. They think that they have the right to be the advocate for their partner, their husband, their well spouse, their whomever. You don't. You may want to be there, but the doctors and the medical professionals don't need to listen to you unless you have a signed power of attorney for health care. Other things that we might talk about today, and I'm going to let Bill take it from wherever he wants to. We have discussions about spousal abuse and what happens, or senior abuse in long-term care facilities. We've got two of those going on today, where the senior with Parkinson's is in the long-term care facility, can't get the medications on time, or they can't get, the help won't help them get to the bathroom on time, or doesn't get to their room when they're ringing their bell for a half an hour. Just many of these things that are legal issues that we want Bill Remery, our esteemed elder law attorney, to address, as well as to take on anything or to add on anything more that he can from Lisa's presentation. Bill, welcome aboard, and thank you so much.
Thank you, Joe. And I have to say, Lisa's presentation kind of leads into the theme or the subject matter of these. You mentioned that with the advanced healthcare directives and powers of attorney. Lisa mentioned that there are exemptions for qualifying for the various Medi-Cal programs, and that certain things, for example, the minimum amount that someone can be can hold in assets, the needs allowance can be increased under certain circumstances. Likewise, the monthly spousal resource allowance, the $3,260 a month, the $3,260 a month, can be increased under certain circumstances if the person has the capacity to participate. There are a lot of things that can be done by way of moving assets around, moving them from the non-exempt category that she listed into exempt assets, or repositioning them. Sometimes, even the ones that she mentioned where they said the couple had under 130,000, but if any of those assets were in the ill spouse's name and the healthy spouse did not have access to them, it might require an actual court proceeding under the probate code to move those assets to the healthy spouse in order to get the ill spouse under their $2,000 limit. So while these programs are there and they're flexible, you can take advantage of the rules. Again, when I say take advantage of the rules, I'm not talking about cheating. I'm not talking about Medi-Cal fraud, which I often get questions about this. Oh my God, what if they find out? No, I'm talking about Medi-Cal planning, like tax planning. If you have a financial situation and some of your income is taxable and you can move it into something that's not taxable, that is tax planning. You're avoiding the tax. If you hide your income or overstate your deductions on your tax return, that is tax fraud, okay? That's tax evasion, not tax avoidance. Well, with Medi-Cal, it's very similar. There's Medi-Cal planning, and that is to move assets into the picture that Medi-Cal likes to see. They allow one of these and one of these and one of these. Well, fine, I'll do those, but they don't let you have two of those. So you take one of those and you put it in the exempt category. That's planning. Medi-Cal fraud is where you hide your money and you don't tell Medi-Cal what you have. Okay, so I'm not talking about the latter. I'm talking about the former, doing planning. But if you are reliant upon both spouses participating in these transactions, that's problematic when one of them loses capacity. So well in advance of the time you need to do the planning, the spouses should have, and this applies to both because we never know which one might have a catastrophic problem, a stroke or something else, should have robust powers of attorney for finance, first of all. Now, the financial power of attorney typically there's a statutory one in most states have them. California certainly does. It's a check the box one, and you have categories of transactions A through K, and if you initial number L, that covers all the other ones. So that it says you can do my real estate and my banking and stuff. One thing it does not cover is the typically Medi-Cal planning or government program planning. So a more robust complete power of attorney should have some recognition that there may be a time when things need to be moved around for one of these plans that Lisa was mentioning, and that even though it may look like someone is being taken advantage of, for example, we have an ill spouse, and we're going to take all the assets out of the ill spouse's name and transfer them to the healthy spouse. Well, that sure looks like the ill spouse is being cheated, okay? It looks like elder financial abuse. It looks like the person making the moves is self-dealing. They're putting money in their own pocket, and that's a bad thing for a fiduciary, for somebody who's handling someone else's finances. However, if while the person still has capacity, is still thinking about these things, they say, you know what, there might be a time when it makes sense to let my spouse take things out of my name and put them into their name, or make gifts to the kids, or in some other way qualify for a government program, or perhaps to avoid Medi-Cal coming back later and asking for reimbursement from assets. There might be a time when that would make sense, even though it looks like self-dealing, or even though it looks like financial abuse. If that kind of language is put in the power of attorney, and later on, someone raises a question. When I say someone, the classic example is someone is in a nursing facility and they're kind of slipping. They don't know much, but all they know is somebody just took my house from me, or my husband took my money from me. Well, the facility is a mandated reporter of potential elder abuse, which is a good thing that they're a mandated reporter, but they don't have much discretion. They just report it to Adult Protective Services. Adult Protective Services then comes knocking on somebody's door and says, hey, we heard this person's money is being taken from them. That's when you bring out the power of attorney. Say, yes, I know that that's what it looks like. But when the person had capacity, she authorized the agent to do these kinds of transactions. And here's what we're doing. And again, everything's above board. Nobody's pulling a fast one here. And you explain, yes, it was appropriate, or it is appropriate to move these over to the healthy spouse, or sometimes to the children, maybe with a lifetime care agreement that the children are providing. So you pay the children with the parent's money to get the parent down below when it's not a married couple. So there are other planning options, but all of this revolves around this power of attorney potentially after the ill spouse or the ill parent has lost the capacity to participate. So that's a big push. And again, it fits into all these programs. And you can change the amount of fund. With a married couple, you have lots of planning you can do, lots of changing both assets and income, shifting back and forth. With a single individual, you have fewer options, but there are still options out there. And the important thing that I'll highlight to, underline that Lisa pointed out is there's a lot of misinformation out there. And if you only get a little snippet, or you only hear the first thing, oh, anybody over $2,000 doesn't qualify for any programs, people stop looking. Oh, I'll never qualify for that. And that's just not true. There are many techniques for this planning. It may be that it's not appropriate to go on Medi-Cal. Maybe there's better things you can do with your finances. Maybe you have better options or more options by using your own funds. But be aware that there are planning options for almost any, whether it's a married person or a single person. There are planning options that you can explore, and then determine, after exploring them, decide which way is best to go. But with a robust power of attorney for finance, someone will have the ability to help you do that planning later if you don't get to it beforehand. The same provision, that same self-dealing provision, that same fiduciary duty clause that is in the power of attorney, I also put in my trusts. If someone has a living trust, if it looks like the trustee is cheating you by moving assets out of the trust or moving them over to one side of the trust, that's problematic. But if in the trust you say, I'm going to permit my successor trustee to make these moves under the very narrow circumstance that it will help me qualify for a benefit or avoid a later claim for reimbursement. Joe, you raised your hand like a good student. What can I do?
But it's not, so I didn't want to really interrupt where you are, because this is power of attorney for finance, or power of attorney different than medical power of attorney. But
Yes.
The question came up on the medical power of attorney. If it is done in another state, is it valid in California? Or if it's done in California, is it valid in another state?
Generally, because we have people, snowbirds and stuff coming in and out of the state, if it was valid where it was executed, California will honor it. I normally recommend that both the will and the advance directive be done in the state of residence to make sure you comply with your residence state. The financial power of attorney and trust, these are contractual things that can be done anywhere in the world. You can do it on a boat out there somewhere, offshore. And as long as it's validly signed, and depending on if it's finance, you probably want it notarized, it'll be recognized anywhere in the world. But the advanced healthcare directive and the will is something that is generally done under the rules of your place of domicile. So wherever that is, I recommend that be done locally, and it can be done. These are forms, again, that are downloadable. Typically, each of the Secretary of States in each of the states has their own form that's easily done. I just downloaded one for a client whose aunt was in Arizona, and the Attorney General of Arizona has their own little pattern form. So I just sent that on. I can't practice in Arizona, but I could download a form for them. So that answers that question. Now, about the significance of the advanced healthcare directive. As you mentioned, people will oftentimes say, well, you know what, this is my spouse or this is my dad. And I go to all my dad's doctor's appointments, and the doctor always talks to me, and I don't have any problems. I don't really need that. And the call that I get typically, and I've told this story before, is that on some Monday morning, I'm going to get a frantic call from somebody saying, I just called my doctor and they won't talk to me. I asked him what, my dad was not very responsive today, and I asked him what kind of meds he's on, and they won't talk to me. They said, you got to go to court now and get a conservatorship over him. What's that about? They talked to me last week. Well, what happened was, over the weekend, the front office staff went to in-service training with their malpractice carriers, and they scared them to death about HIPAA, the federal privacy program for medical information. And they told him, if you give out medical information to anybody, relative or non-relative, who does not have an advanced healthcare directive, you're violating federal law, you're going to go to prison, you're going to get sued, yada, yada. So when you call the front office and you talk to the secretary and they say you want to talk to the doctor, they won't put the call through to the doctor. They're afraid the doctor will, in fact, talk to you. They are the firewall. They're going to prevent the doctor from even talking to you if they can help it. So the thing to do, though, is an advanced healthcare directive is one of the simplest forms to do. Notwithstanding is maybe one of the most important documents to do. It authorizes an agent to make medical decisions, or at the very least, to access your medical information to talk to your doctors on your behalf if you lack capacity. Now, if you wish, you can also add in this document, that's why it's called an advanced directive. The power of attorney part is naming your agent. The advanced directive part is giving some guidance to your agent. How do you feel about ongoing life support if you're in a coma? How do you feel if you die? How do you feel about being an organ donor or not? Do you want to say anything about the disposition of your remains, whether you should be cremated or buried, or whatever? You can have, there's lots of optional stuff you can put in there. If you leave that all blank, that's okay. Just understand your agent then will have discretion to make those decisions. The more you care about those items, and the more significant those are to you, the more you should fill it out and be complete. And frankly, talk to your agent. That's as equally important as to putting it in the document, because nobody's going to take that document and make it self-activating. They're not going to say, oh, in the advanced directive, they said, I don't want a life support, and therefore we're not going to give life support. That's not true. They say, here's an agent. They're going to call the agent. Now, they may point out in our advanced directive, she said she didn't want ongoing life support. So is that what you want us to do? But it's the agent who makes the call. So name a person that you trust to carry out your wishes, and then talk to them about what your wishes are. In California, I don't know if it's unique in all the United States, but it's the only state I'm aware of that you can also name someone in your advanced directive whom you do not want to participate in any medical decisions, whom you do not want to have any say-so if you need a conservator, if you do not, and you do not want to participate if somebody needs to get authority from a court to implement a medical plan. You can actually name someone who you do not want to have standing to go in and complain to the court. Oh, judge, my sister is making a bad decision about my mother. If you're named in there and it says this person is to have no say-so in it, they lack standing. They can't even go in front of the judge and do that. So it's a little known thing that a lot of people don't realize, that if there is we call it inofficious interloper, if there is someone in the family who's a busybody who just wants to control everybody and everything, you can actually name them to keep them out of your life.
That's really interesting. We have that going on this very day. And it certainly is an issue when you have someone who is incapacitated and hurting because they're in a medical facility, and one of the family members has taken it upon himself to interlope, if you will, and unfortunately told the facility what to do and not do, and they followed that. But there wasn't anything that said he couldn't do that. It's just that he didn't have a paper that said he could do that. And now the spouse is upset and up in arms because it's the child that actually did something that was damaging to the whole of the situation. It's so very important. I keep telling everyone, and I'm so happy people are listening to you, Bill, I mean, what Lisa said and what you said, these are such important things that take so little time to get done if you just get there and get them done. But you need the right people. So for that, we will talk to anyone who is not in the state of California and you need an elder law attorney. Please get in touch with us. We will help you find somebody in your state that we know can do what Bill is talking about today. We will help find somebody. There's no replacement of Lisa, no matter where in the world, but we'll help find somebody that can do what Lisa can do in your state. So get to us, though, and let us help you get to those resources. Because this is, the next thing would be spousal abuse. No, not spousal abuse, senior abuse in a care facility when they probably don't have enough staff to be doing to take on any more patients, and they're not attending to the patient. In Parkinson's, one of the issues is medication, taking it timely. And we have this issue where the person is not getting their meds on time. They even lost the meds for the second time in a row. And how do you lose medicine? And so what do you do in a case like that? Is that something in your territory?
It's not really. I don't do the physical neglect and elder abuse, but I run across it tangentially in other things that I do, and of course in my work with the courts as a court-appointed attorney for people, particularly in the conservatorship area. The one problem is just since COVID, the inability of family to attend to their loved one, the restrictions on visitation, contact in general, has created, I won't say a backlog of dealing with complaints, but it has made it more difficult to identify problems and then to do anything about them. We've always had the ability to report to the state, to the licensing agencies, Department of Health Services and whatnot, if you think something is going wrong in a facility, and they are to send someone over to investigate. We also have the patient ombudsman program, and you can contact the ombudsman to say that you believe the facility is not taking care of their residents. Problem is, doing everything remotely, there has been no feet on the ground. Now things are opening up now, mercifully, and people are being able to visit people, at least in some restricted ways, but more so than last year. And so hopefully more of the tales will come to the surface. And but I'm sure there's going to be a huge backlog of complaints at the Department of Health Services, and this is truly a squeaky wheel type of situation, that it takes someone to stay on it, keep complaining, raise the visibility. And of course, we always have concerns. If I'm the complainer, are they going to take it out on my loved one? Well, I guess there's that possibility, but more likely, particularly with the larger facility where these are sort of a business, it's more of a business corporate atmosphere, they don't want criticism and they will respond within the limits. Now, if they're understaffed, it's not going to help. You can complain all you want, and there just aren't enough people to go around. Or what will happen is your loved one will get the care, and just the guy down the hall, they'll have to get less care. We run into this, and I've been preaching this again for the 42 years I've been doing this, is that all nursing type care is sort of the squeaky wheel paradigm, in that if you have someone in a facility who gets regular visits from people at irregular times, so they don't know when you're going to show up, they get the best care. The people who have the most outside interested people taking care of them already will get the best care. And perversely, the people who have nobody looking out for them, who are getting no care at all outside the facility, when they get in a facility, they're the last ones to get fed. They're the last ones to get changed, because it's the squeaky wheel. The facility doesn't want to be criticized, and they're unlikely to be criticized for not taking care of somebody who's nobody's checking up on them in the first place. They're going to be criticized for the person who's used to being taken care of well, and all of a sudden isn't getting their meals right on time. So for whether it's a friend or a relative, first of all, and of course, again, with COVID, we couldn't do this, but now as things are opening up, it's having constant contact with the loved one, showing an interest in it. And number one, and this is overlooked, unfortunately, more than I'm shocked at how often it's overlooked by facilities themselves. Every patient in every facility is supposed to have a care plan, a specific care plan that has in it what kind of extracurricular activities they should be having, what kind of exercise they should be getting, a plan. And in the vast majority of cases where the court appoints me to represent a proposed conservatee, and I go in and I look at medical records, there's no plan. Yeah, they'll tell me what time he got up in the morning, what did he eat and whatnot, but there's no real plan there. So one thing is to advocate for a plan, come up with a plan, and then make sure they follow it.
And Sandy Rodley put a note in the chat room. It's advocate, advocate, advocate. We talk about that at every meeting that we possibly can. So we're going a little over, and we're going to cut Bill out a little bit tonight. We're going to bring Lisa back in if we can do a threesome picture here. But one of the things so Bill does other things. He talks about wills versus trust. We used to do 2 hours, 2-hour meetings on this kind of thing in the old days. What else might you, topics that you think that our audience might want to hear from you? That's one way of putting it. Or to you, the audience, if there is something that's a legal issue that you think others would like to know about as well, please let us know what those issues are, and we will get someone to address them for you, and that will also help others who may have that same concern. Is there anyone, if you can, it's hard for me to see who has their hands up, but if someone has their hand up and wants to talk to Lisa, Neil Friedman does, either Lisa or Bill. So Neil, unmute yourself and ask your question.
Okay, can you hear me now?
Yes.
Well, I want to say from the bottom of my heart, this is the most invaluable information that one can get. It's like taking a college course, kept in a layman's term where we can understand and digest it. And I commend you, your resources for this unbelievable information. That's why PRO needs support from all of us to enable these kinds of presentations. So thank you. So I have one question for Bill. Bill, in a family trust, I live in Woodland Hills, California. If I wanted to call you, can we do this over the phone or virtual? If I wanted to do a trust and a will with you to update mine, can we do it virtually? Okay.
Actually, we're only doing it virtually right now. We're still not doing in-office meetings.
Right.
Mostly by Zoom, because it helps to, again, like this, see your eyes. I can tell if they start glazing over when I get in the weeds. I can kind of back off a little bit.
Right.
That's been working very well. And in fact, even post-COVID, I think this is something that's going to stay, because it's just too handy for people.
Good.
Rather than taking a whole day off of work to drive to Glendale. We've been doing it. So the short answer is yes, we can just do that.
All right, so you're in Glendale.
Yes.
Oh, perfect. That's fine. All right. Now, thank you very much, Bill. Now, Lisa, if I wanted to speak to one of your associates to get an assessment, if I can qualify for Medi-Cal. I do have long care insurance right now, and we are using it for my wife Sharon with Parkinson's. But is there somebody in your organization that I can speak to that maybe guide me? And if there is a fee, I'd like to discuss that with you. So what can you answer that question for me?
Absolutely, Neil. Thank you for a perfect question. If someone is interested in how their circumstance relates to Medi-Cal, and they'd like to understand how they can qualify and how it can help them and what they need to do, the first thing you need to do is go to our website, which I put in the chat box, but I can tell you now, it's real simple. It's Medi-Helper. That's MEDIHELPER.com, Medi-Helper.com. And on the home page, in the top right-hand corner is a big orange button. It says free Medi-Cal assessment. So you click on that, Neil, and you complete the assessment. It takes about 2 minutes. It's real simple. We ask some basic information. Once you submit that, an option will come up for dates and times. You choose one of those dates and times that is convenient for you, and we'll call you at that time and we'll go over your assessment. We'll answer your questions and we'll help you understand so you can make an informed decision. And Neil, all of that is free of charge with no obligation.
Thank you. And I want to go back to Bill. One thing, I have a friend that's going into a care facility post-surgery to go into rehab. And if it's in a rehab facility, do I ask if they have a care plan in place at this facility for that person? Is that appropriate?
If it's going to be longer, if it's going to be for just the rehab, limited rehab, that is the plan. The rehab, there will be a rehabilitation plan is going to say how many hours he should get and what provisions are.
Right.
If it extends beyond that, then it needs a separate plan for the ongoing stay.
So there's two parts to that, is what you're saying.
Right. The initial admission is for a specific purpose, the specific rehab purpose.
Correct.
That there is a plan. There will be a plan. That's how they code it for Medicare and everything. Because
Right.
it's going to cover the first 20 days potentially, and up to the next 80 days with a copay, if depending upon what needs to be done.
Right.
But if it turns into a long, and many times then it does turn into a longer term admission, then they need a new plan. They need to, and that's where the ball gets kind of dropped. Somebody gets in there under one auspices, and then nobody follows up to say,
Right.
oh, we really need a plan for this person. What are we going to do for the rest of their life?
Right, exactly.
Neil, also, that would be a really good question to ask on June 28th, I think it is another village meeting where we have Vibra Rehab speaking. And I would love to know about their plan. There's a difference between a rehab facility and a rehab hospital. And that's what you're going to learn in that particular village meeting as well. So, but let's ask our Vibra people if they have a plan and how that works. I would, this was a good answer, but let's ask directly to the horse.
Thank you. Thank you very much to both of you, and Joe and everybody at Pro. Thank you again.
You're welcome, Neil. And also, if I could kind of piggyback onto that, a lot of facilities, they call themselves different names, whether it's a rehab, it's a post-acute, skilled nursing facility. It's just the way they market themselves. It's all one and the same.
Right.
So, but Neil, if you're regarding your friend who's going into a rehab center, which is a nursing home, if you'd like, you can have him do an assessment on our website, and we can help him understand how to qualify for Medi-Cal as well.
Okay, thank you. Thank you again. God bless.
I love these meetings. There is so much information here, as we call them nuggets. And there were nuggets out of every speaker today. I sincerely hope that everybody gained a lot from my manifestation and Parkinsonisms, etc. Understanding that we leave no stone unturned, really important information. Donna, as usual, and Tyler and all our support staff have put information into the chat room. So save your chat room so you can go back and get websites and whatever information is needed there. And I can only say from the bottom of my heart, Lisa, thank you. Always nice to see you. Always good to hear your information. I love the fact that you and Bill were on the same dais today and that you both got to talk to each other. I wanted this opportunity to be like this and never knew when it was going to happen. Today was it.
There was some great synergy today.
Yes, I think, and there is. And so when somebody says it takes a village, it does. It takes a PRO village. It takes a Parkinson's Resource Organization village. And we get the job done, and we help everybody get through their journey in the best way possible. It's time for dinner now. It's like 5:42. We went a little bit over, but that's all good because it was all good information. We thank you. Thank the staff, each one of you. Say goodbye today, and we'll see you at the next meeting. Love.